Good morning, everyone. Welcome to our HHQ webinar. We are glad to have many esteemed attendees with us today for our webinar on claim for liquidated ascertained. So, before we kickstart this section, please be informed that all participants will be muted, and if there are any questions, please type in the chat box and we will discuss them during the Q&A section later. Please scan the QR code appear on your screen for attendance purposes. So now, please allow me to introduce our speaker, Mr. William Lim. He is active in real property and project development practice. He has represented housing developers in sale transaction with regards to both residential and commercial properties. In banking and finance, he advises major financial facilities of both conventional and Islamic financing facilities. So please join me to welcome our speaker, Mr. William Lim.
Good morning, everyone. I'm William Lim from Harley Tong and Quack. Today, I'm going to share the topics claim for liquidated damages for you all. So, first of all, we need to know what is liquidated damages. When a developer fails to deliver the property in accordance with the timeline provided in the sales and purchase agreement, a purchaser has the right to seek legal resource based on the terms on the SPA. One such term is the obligation for the developer to pay the liquidated damages, or we call it LAD, for the period of the delay. So LAD is a contractual agreed fixed or predetermined amount of damages which shall be claimable either contracting party who has suffered loss in the event the contract is breached. For the contract under the Housing Development Control and Licensing Act, especially Schedule G or Schedule H, there is certain clause mentioned about LAD. So according to the clause 24 sub 1 of the Schedule G of the HDA and also clause 25 sub 1 of Schedule H of the HDA, they provide the statutory form of the SPA, where a purchaser has the right to claim for a LAD for any delay in the delivery of vacant possession. So the clauses above, which are common in most but not all SPA, provide a statutory remedy for a purchaser for any failure by the developer to fulfill its contractual obligation to deliver the vacant possession of the property by a specific date. So now we can look into the 2024 of the clause 24 of the Schedule G and also clause 25 of the Schedule H. Clause 24 of the Schedule G said the vacant possession of a property shall be delivered to the purchaser in the manner described in clause 26 of the Schedule G within 24 months from the date of this agreement, meaning that after 24 months of the date of this agreement, if the developer failed to deliver the vacant possession to the purchaser will have the right to claim for the LAD. The similar clause is mentioned in clause 25 of the Schedule H, which mentioned that the vacant possession of the parcel should be delivered to the purchaser in the manner stated in clause 27 within 36 months from the date of this agreement. So the period for the vacant possession is different between Schedule G and Schedule H. For Schedule G, it is 24 months, whereas for Schedule H is 36 months. Okay, so next we'll discuss about how the LAD is calculated. The calculation of the LAD is mentioned in the section 24 sub 2 and also section 25 sub 2 of the Schedule G and Schedule H. So let's look at the Schedule G first. 24 sub 2 of the Schedule G said, if the developer fails to deliver the vacant possession of the property in the manner stated in clause 26 within the period stated in subclause 1, which is 24 months, the developer shall be liable to pay to the purchaser the damages calculated from day to day at the rate of 10% per annum of the purchase price from the expiry of the period mentioned in the subclause 1 until the date the purchaser take the vacant possession of the said property. So the similar clause is mentioned in the 25 subclause 2 of the Schedule H. Okay, so in the clause 29 of the Schedule H, they mention that during the vacant possession, the common facilities shall be passed to the purchaser at the same time. So clause 29 subclause 1 of the Schedule H mentioned that the common facility the house shall form part of common property which shall be completed by the developer within 36 months from the date of this agreement. The developer's architect shall certify the date of the completion of the common facilities and the copy of the certification shall be provided to the purchaser. So if the developer failed to pass the vacant possession of the common facility to the purchaser within 36 months, the purchaser shall have the right to claim for the LAD calculated from the day-to-day basis at the rate of 10% per annum of the last 20% of the purchase price. So this will be the scenario for the situations that the purchaser has the right to claim for LAD. So let's say the purchase price of the property is 800,000 and the sales and purchase agreement is dated 18 August 2015 and the booking fees is paid on the same day also. So the expected date for the vacant possession will be 17th of August 2018 according to the Schedule H of the SPA. But then in this situation, the developer, they hand over the vacant possession to the purchaser of 18th of August 2019. So in this situation, the number of day delay is 366 days. So the calculation will be the property price, which is 800,000 times 10% times number of day delay, which is 366 days delay, divided by 365 days. So the total LAD can be claimed by the purchaser will be 80,219.20. So at the same time, as mentioned in the clause 29 of the Schedule H, the developer shall pass the common facility to the purchaser within 36 months from the date of the agreement also. So the purchaser will have the right to claim for LAD for common facility as well. The calculation will be the property price times 10% times 20% times number of day delays, which is 366 days divided by 365 days. So the total LAD the purchaser can claim for the common facilities will be 16,043 ringgit and 80 cents. So when we discuss further, we will discuss about when we calculating the damages, the LAD for the late delivery of property, when does the clock start ticking? The SPA mentioned the date of this agreement. So what is the date of the agreement? And after that, when we want to stop the calculation, what is the cut-off date for the calculation of the LAD? So now we look into the calculation of damages. When does the clock start ticking first? The first issue, when should we start to calculate the LAD? So first we look into the some case law to discuss about this issue. The first case law we are going to share is GJH Avenue Seremban against Tribunal for Home Buyer Claim. So in these situations, the purchaser, they fill in the application form of the unit from the developer and pay the deposit on the 24th of August 2011. And in the 3rd December 2011, with the developer's consent, the purchaser cancelled his name and replaced it with two names. And subsequently, in the 3rd of December 2011, the purchaser paid the balance of 10% of the purchase price. And on the 3rd of December 2012, the purchaser signed the sales and purchase agreement. And at the 14th of February 2014, developer issued a notice of delivery of vacant possession. And on the 1st April 2014, the developer paid 20 ringgit 20 cents to the purchaser for the date delivery of the two days. The purchaser accept the payment without any further dispute. So the issue in this case in GJH Avenue is, in the context of the circumstances of this case, when does the clock start to tick in calculation of LAD? Is from the payment of the booking fees or from the date of the SPA? In this case, the Court of Appeal allowing appeal, and the reasoning is as follows. The court emphasized that the issue in the question need to be addressed in the light of relevant provisions in SPA itself. Specifically, the court look at the clause 22 of the Schedule G. The vacant possession shall be delivered within 24 calendar months from the date of this agreement. The court pointed out the clause 22 is clearly worded and very clear that it must be given its plain and literal meaning. So when the letter of the law is clear, we must take heed of it, and there is indeed nothing to interpret on. So the conclusion is, in this case, GJH Avenue Sendirian Berhad, the court held that the date of the agreement, the calculation of the LAD will start from the date of the agreement, not the booking form, not the date where the purchaser paid the booking fees. So the court further the reasoning saying that the Schedule G is a statutory contract draft by the government, which does not allow the party to contract out of the schedule form. In addition, the law specifically Regulation 11, Sub-Regulation 2, HDR 1988, they prohibits the collection of any payment of the deposit which is not provided in the statutory SPA. It follows then the law doesn't recognize the notion of the booking fees in the context of Schedule G or Schedule H. The approach taken by the court in this case necessarily means that the phrase of the date of the agreement for the purpose of the calculating of this LAD. So, but for the GJH Avenue Ceremony case, actually this is the old judgment. There's a recent, newest, the latest federal court case, PJD Regency Sdn Bhd against the Tribunal Tuntutan Pembeli Rumah, which is this is the final and the latest judgment for the issue. So the judgment given by the court in this case is the calculation of the LAD for the late delivery of vacant possession must run from the date when a purchaser pays the booking fees, not from the date of the agreement. So let's look at the decision of the Court of Appeal before when the case go to the federal court. In the Court of Appeal, the judge give the decision that based on the Supreme Court decisions in Ho Si San and the Faber Union, it is a law that the LAD, the ascertained liquidated damages for the late delivery of a vacant possessions start to run from the date of the payment of booking fees or deposit, not the date of the agreement. The decision in the Faber Union has been followed by a series of the subsequent cases whenever the court have been called to determine the date from which liquidated damages for the late delivery starts. And the applicant's contention that the booking fees paid was merely to secure the purchase price of the property pending the procurement of the financing, and the date of payment of booking fees should therefore not be used for the purpose of calculating the date of delivery of vacant possession is not acceptable. Clause 1 of the SPA indicates that the payment of booking fees accepted by the appellant will amount to an offer and acceptance. Accordingly, the appellant must build and deliver the vacant possession to the purchaser within the agreed period. So after that, this case is appealed to the federal court, and recently the federal court just gave the decision. So in PJD Regency case, actually they have 3 appeals involved. So in the latest landmark decision where this federal court has heard these 3 appeals together, which the appeal from PJD, the appeal from the GJH, and also appeal for the Sri Damansara case. The federal court held that the date of this agreement mentioned in the Schedule G and the Clause 25 of the Schedule H shall be the date of the booking fees paid, not the date of the SPA signed. So in arriving the decisions, the federal court has taken into some considerations. The first considerations is the decisions of the Supreme Court in Ho Si San and Faber Union, which this ground is similar in the Court of Appeal case before. The court is, in the view of Faber Union, decided in the same fashion as Ho Si San that the date of the calculation of LAD runs from the date of the booking fees were paid, but not from the date of signing of the agreement. And then the federal court case held that the Faber Union or the Ho Si San's case actually is a good law. And also the second ground taken by the federal court case is the concept of the social legislation. So the long title of the HDA 1966 provides the protection of the interest of purchaser and for the matters connected herewith. When it's come to the interpreting the social legislations, the court must give the effect of the intention of parliament, but not intention of the parties. So the court basically means actually this HDA is to protect come out a decision, right, they should go into the intention when the parliament to draft this HDA, but not the intention of the parties like the developers or the purchaser. So the third ground taken by the federal court case to come out this decision is the legislative history and also the statutory interpretation. The illegal collection of the booking fees by the developer binds the developer to the booking fees of having to bear to the full extent of LAD payable to the purchaser, consistent with the overall intent of the written law of protecting the purchaser of the late delivery of vacant possession. And also one of the ground taken by the federal court case is the formation of the general law for the contract. So basically, a valid contract come into being when the purchasers pay the booking fees to the developer. The date of the calculation of the LAD should therefore begin from the date of the payment of the booking fees, which means the day when this contract is formed, but not from the date of the SPA literally. So this is the summary of the federal court case decision to the debt 3 appeals. So for the PJD Regency, the court held that the calculation of LAD in respect of the common facilities depends on the date of the CCC was issued and not the date when the CPC, the Certificate of Practical Completion, was issued. And in the GJH Avenue cases, the date of the commencement of the LAD should start from the booking fees paid and not from the date of the SPA. And also for the Sri Damansara cases, it was the developer's own contribution of the law of collecting the initial payment or the booking fees from the purchaser. And it express is a contribution of the regulation 11 of the HDA 1989. There's therefore not a unjust enrichment upon an innocent party's right to enforce its statutory remedy of the LAD against a party in breach. In further, any rebate discount given to the purchaser, it will not alter the position of the LAD shall calculate on the original purchase price. Meaning that even though the developer give the rebate, give the discount to the purchaser, right? The LAD should calculate based on the original purchase price before the rebate and also the discount. So if you want to know further for these informations, you can refer to the article written by our colleague. The first article is written by Kashmir. The topic is calculating the damages for the late delivery of vacant of the property. When does the clock start ticking? And also the recent case update written by our colleague Su En. The article's name is the Federal Court decides that the time for the delivery of vacant possession runs from the date of the payment of booking fees. Both these two articles can be obtained in our HHQ website. So now the second issue is what is the cut-off date of the calculation of the LAD? So just now, in the clause 25 and also the clause 27 of the Schedule H saying that the delivery of vacant possession must be delivered in the manner stated in the clause 26 of the Schedule G and clause 27 of the Schedule H. And this is the manner mentioned in the Schedule G and Schedule H. The manner is the developer shall let the purchaser into the possession of the said property upon the following. First, the issue of the certificate of completion and compliance or CCC. Secondly, the water and electricity supply are ready for connection. Thirdly, the purchaser have paid all the monies payable under the third schedule. And fourthly, the completion of any alteration or additional work have been done. And then the delivery of vacant possession must be supported by the CCC, includes the handing over the keys of the said building to the purchaser. The similar clause can be is provided in the clause 27 of the Schedule H also. So in the average point, Sriam Berhad, the judgment from a judge is that the cut-off date to deliver the property to the purchaser, right, is the date when the purchaser is being notified or deemed delivered. So in this case, the court held that for the above reasons and based on the facts and circumstances for the instant case, it was of finding that the unit in the question have been completed and was safe for occupation as certified in the CFO, which is issued on 25th of May 2011 and notified to the plaintiff on 30th of the May 2011. So in the early notification by the first defendant dated 16 September 2010 was invalid. Well, in the view that the effective date of the delivery of vacant possession in this case was the date when the issuance of the CFO by the relevant authority was notified to the plaintiff, which was on 30th of May 2011. So in the other words, the cut-off date of the delivery of vacant possession will be the day when the CFO is issued and the purchaser is being notified by the developer. Whereas for the common facilities and as per the case in the PJD just now, the cut-off date to deliver the common facility should be the date when the CFO or the CCC is issued. So
Thank you, Mr. William, for the enlightening sharing. I'm sure it is very helpful to many, especially our attendees today. So now we have come to the Q&A section for this webinar. You may post your question in the chat box if you have any question. Is there any question? Okay, so if there is
no, the federal court case never said the booking fees is legal. So actually, the court never said the developer never give the right to the developer to collect the booking fees.
there is another question from Serene Hill. So the question is, the calculation of LAD will still be from the booking fee, yeah?
Yes, the calculation of LAD will start of the payment of the booking fees according to this recent federal court decision.
Okay, so if there is no more question, please scan this QR code to give feedback on our section today. So dear participants, our next section is assessment section. Now, please scan this QR code for the questions and please submit your answer within 10 minutes. Okay, I believe that's all the time we have today. This marks the end of our webinar. Thank you very much for joining us.